Welcome to the Nichols Tax Update Podcast for May 10th, 2021, Issue 21-19. This program is produced to provide current information about developments in United States tax law, cases, rulings, IRS pronouncements, and expert comments on hot topics. You are receiving it as a member benefit from the South Carolina Association of CPAs. My commentary is necessarily brief, and you should consult appropriate authority before taking a position on any item discussed in the program. And I always acknowledge the value in preparation of this program of my subscription to Tax Notes Today, published by tax analysts, the preeminent source of information for tax professionals, and my primary source of information for all things federal income tax related. Let's take a look at what we have this week. There's a new K2 and a K3 to help partnerships better report international transactions that affect their partners. With an interesting comment or two about that. And then the goofiest innocence mouse case ever. Never seen one like this because there is no liability. How can that be? The judge wondered the same thing. Then the IRS allows, they've explained how they're going to allow a proprietor, an entrepreneur, who owns his or her own airplane and uses it in the conduct of their trade or business to determine deductibility for a trip, expenses of a trip, based on the primary purpose rather than under Section 162, rather than on some kind of allocation rule under Section 274. Then next, raising money to help one person is not an exempt purpose, and the IRS will not grant you exemption, or your organization exempt status to do that. Speaking of IRS positions, here we have an IRS position substantially justified because the taxpayer was a jerk. The taxpayer refused to provide detailed information about the deductions he claimed. He was engaged in 3 different income-producing activities, and so he made the job of the IRS as difficult as possible, and so he didn't produce the real information until he was in an appellate conference. And the IRS, when they confronted finally with the information, said, well, okay, so, but there's no fee award for that. Then expenses of operating a race car, what? Wait a minute. We just talked about this guy. Yes, we did. And we did. I want to tell you the whole story about this gentleman's race car and his experience with the IRS. And the 8th batch of economic impact payments is out. The check's in the mail. So watch for that. Finally, the exempt status of an African art exhibitor is revoked for failure to operate exclusively for one or more exempt purposes under Section 501c3. And that's a direct quote from the regulations and from the IRS private letter ruling and from the tax court's upholding of the IRS position. Well, let's go. Let's see what we got for detail. The new K2 and K3 for pass-through entity international transactions. Partners and S-Corp shareholders are going to get a lot of information if the partnership or the S-Corporation is engaged in any transaction with international significance. So I guess first we need to say the changes do not affect partnerships and S-Corporations with no items of international tax relevance. They're not going to get a K2 or a K3. They're going to just get the traditional form, a Schedule K1. Second, 2021 is an education year, and the IRS understands that providing a form that is 20 pages long is likely to involve some compliance issues. So they're going to provide relief from penalties or for late compliance for the tax year 2021. Good records and full documentation of all transactions would seem to be essential here if the partnership or the S-Corporation is engaged in any transaction of international significance. And by the way, let's take a look at what that K2 looks like. Wow, that's just part of page 1. It is highly detailed on every page, requesting a lot of information, details about every kind of transaction with any sort of foreign involvement or the effect on U.S. taxation of a foreign transaction. A divorced husband seeks protection from no liability. What? Wait a second. The judge had the same problem. Mamadou Lamine Fati. And this is a tax court bench opinion. We'll talk a little bit about what that is. Tax court judges issue bench opinions when the case before them raises legal and factual issues the judge can quickly resolve. In this case, Judge Holmes was able to resolve this out of hand. Tax court rules permit the judge to go on record and read the opinion into the record as a bench opinion if the judge can do it during the same calendar, usually a weekly session, in which the trial of the case takes place, so the parties can be immediately informed as to the disposition of their case. That's a lot better than what we're waiting months currently to get written opinions from the tax court. In this case, the divorced wife was current. She was occupying what had been the family home. She's current on her obligation to make payments on a loan for which both parties were liable. She took the loan out of her retirement plan to fund the acquisition of this home. Then the couple split. She stayed in the home and she's making the payments on the loan. But her former husband is still liable and he doesn't want to be liable. But the lender will not release him. He wants the judge to tell the lender to let him go. The judge said, "Not my job. I don't need to be involved in this. If your former wife does not make the payments, you can take her to small claims court. But there is no provision in federal tax law for relief from a spousal liability where there isn't any." So perhaps Mamadou needs to learn a few lessons about U.S. tax law. I don't know. Maybe he's been here a long time, but maybe not. I've been here a long time, and I don't understand U.S. tax law sometimes either. Another rule for aircraft expenses, an internal legal memorandum in which the IRS intelligently concludes that the Section 274 regulations apply to valuing the use of an aircraft for employee benefit purposes and compensation of an employee. Well, since the proprietor, the entrepreneur, is not an employee, nor is he the employer, there is no way to apply the allocation regulations that in Section 274. But there is a way to take a look at a trip and ask, what is the primary purpose? If the primary purpose, the principal purpose is business, then the costs of the trip are deductible. That's easy, right? So a sole proprietor, pursuant to this reasoning, now this is not a regulation, this is not an IRS, this is not a revenue ruling. It's a little window into how the IRS thinks. Is it cold? Is it a cold, dead winter? No, probably not. But it certainly is the kind of logic that you would use to support a return position, and you'd probably very well succeed. And the IRS is just trying to explain how they think about this, and it makes a lot of sense to me. Maybe it makes sense to you. The proprietor is not an employee, nor is the proprietor the employer. The Section 274 regulations deal with allocating the cost of the aircraft between the employer and the employee for purposes of determining compensation or deductible expense. We don't have an employer, we don't have an employee, so we go to Section 162, the business deduction, a deduction for expenditures that have a business purpose, and there we are, and the IRS agrees with that we can use the Section 162 regulations. No exemption for an organization helping one individual. I had to scratch through the clip art to find this one. Letter ruling. The evening news carries a heartbreaking tale of a personal disaster. A family is homeless. An individual is facing enormous medical bills as a result of a hit and run. Worthy and honest causes. We should organize a way to get a charitable deduction for contributions to help out. Send your contribution to, but wait, not so fast. The Salvation Army can help. The Red Cross can help. You can contribute to them because they serve a charitable class. There can be no tax-exempt status for an organization or a fund that serves private interests by raising money to help a specific individual or that individual's family. It just can't be done. And so whoever prepared the application for exemption wasted their time, and if they did it for a fee, they wasted somebody's money. Everyone involved should have known better. Taxpayer wins and then loses. Dennis Jacobs, I told you about him in my opening statement there. He prevailed against the IRS on business deductions, but he isn't entitled to an award of litigation fees. Notice the cartoon. Ha-ha, I won the battle. Ha-ha, I won the war. Who won what, right? The agency was justifiably skeptical that the expenses were not deductible because Mr. Jacobs' descriptions lacked sufficient detail. They lacked specificity about where they went. Were they expenses of his work as an author, producing a book? Were they expenses of his work as an attorney? Or were they job-related expenses which would not be deductible since he was an employee of the university as a professor? Only after Mr. Jacobs sat down, after months of back and forth, actually years of back and forth with the IRS on this, only after he sat down with an IRS appeals officer in order to avoid going to tax court and went over his deductions item by item, line by line, did he produce the evidence that the IRS needed to sort out his expenses as to what was deductible and what was not. He didn't win anything. He was a problem. He created problems for the Internal Revenue Service. He was a compliance nightmare. He's certainly not entitled to any fees when the IRS finally gets the information and they say, oh, well, now that we have the information, we understand that your expenses are deductible. Jacobs was the author of his own discomfort. Give the IRS the proof and the evidence and the explanation in the first round. Don't hold out and then expect to get any kind of special consideration if you incur time, costs, expenses defending yourself. Another lap around the same track, same car, same result. Andrew Mitchell Berry, been here before. When I looked all this up, Andrew Mitchell Berry was in tax court in 2018 on his 2011 tax return. Then he was back in tax court a month and a half ago on his 2013 and 2014 returns. He's in tax court here on his 2015 return. The same issues, the same race car, the different amounts, obviously. And you say, well, did he learn anything? Well, it was too late. By the time the IRS audited the first return with these expenditures disallowed, they were already several years down the road. Pardon the pun with the car here. They were down the road. So the taxpayer here still had several years when the taxpayer had been doing the same thing that he lost on back in 2018. Now, why the taxpayer and the IRS continued this battle when they could have predicted the outcome and the taxpayer could have avoided the additional expense of litigation made no sense to me, except I think the taxpayer was enjoying the go-around with the IRS. Taxpayer was pro se, defending himself. Didn't make any sense. So perhaps he got some thrill from going to court and arguing with the IRS lawyers, even though he lost. Maybe it was worth it. The court sustained the IRS's disallowance of some Section 179 deductions. When they start the audit, they're going to find whatever there is to find, you know? And so you really would just as soon settle with them on the easy issues and go on, as I said, down the road. Money's on the way. I know there's some kind of a commercial on television. Money's on the way. Again, the IRS announced on May the 5th, more than 1.1 million payments are being distributed in the 8th batch of economic impact payments. These are the last payments to be made under any kind of authorizing federal legislation, bringing the total disbursements so far to about 164 million payments. And I don't think anybody knows how much money that is. I suppose we'll find out sometime. Here's something that obviously had some political sensitivity to it. This is a revocation of African art exhibitors' tax-exempt status. There's involvement with African politicians, African museums. Our U.S. taxpayer is an African-American heart specialist, coronary doctor. So this thing drug on past when it should have, I think, because there might have been some political considerations. But the IRS determined that the IRS revoked this exempt status back in 2018. They had granted exempt status in 1999. So this outfit operated kind of loosely. They made what looked like business arrangements with African organizations. They paid commissions, and they took commissions. They helped anyone who would help them sell art. They would keep a percentage of the sales price and let some part of the sales price go to another museum or another exhibit. All of this came to a head when they tried to bring the whole thing back to the United States, and they made private arrangements and actually entered into contracts that allowed participation in their activity, like you would allow participation for a shareholder for 3 U.S. individuals. Doesn't work that way. Their finances were a bit sketchy, and between 1999 and 2015, only 1 exhibit was conducted, although hundreds of thousands of dollars were raised and spent. Ownership interests in the collection, which was purportedly the property of the exempt organization, were granted to 3 individuals, as I mentioned a moment ago. The documents that they provided in response to IRS document requests were unsigned and undated, and obviously not notarized if they weren't signed. The IRS concluded that the organization was not operated exclusively for 1 or more exempt purposes under Section 501c3. The organization appealed to the U.S. Tax Court, and they lost. Takar Inc., they lost May 6, 2021. Finally, a saga that began in 1999, actually began in 96. The exempt status was granted in 99. A saga that began in 1996 finally ends in 2015. None of that activity related to Takar is going to generate a tax deduction for anybody if they made any payment after 2012. That's the effective date of the revocation. Well, that's it. Again, time goes so quickly here. Thank you. Thank you for joining me every week. And remember, please, to stay safe. It's going to take all of us to get through this, working together. Thank you.